Good evening once again. Here we are once again. I remain your thread legal scholar, and I'll be continuing from where I stopped last week. So, if you can remember, last week we talked about a concept in international space law, which is the principle of non-appropriation. And today we are going to be discussing an issue that is related to that principle, and that issue is the theory of resource exploitation as it relates to international space law. So, we'll begin. We'll start with the definition of resource exploitation as shown on the screen here. So from my screen here, you can see that resource exploitation refers to the act of extracting and utilizing natural resources found on celestial bodies like the moon or asteroids, essentially meaning the process of mining or harvesting these resources for economic or scientific purposes, with the key legal implication being that such activities are currently considered to be part of the common heritage of mankind under the Outer Space Treaty, requiring international regulation and governance before any nation or private entity can engage in extraction. So from the definition of resource exploitation, we have been able to derive a number of things. The first is, it refers to the act of extracting and utilizing natural resources that are found on celestial bodies like the moon or asteroids. Now, last week when I was talking about the principle of non-appropriation, I talked about resource exploitation of the moon and the asteroids. Now, the question was whether any part of space can be owned by any country or any private entity, and the answer is no, as it currently stands. However, the issue as to whether resources can be owned by individuals or private entities or the states in the world is a debatable issue. Now, currently, the only agreement that talks about resource exploitation being for the benefit and the use of common heritage of mankind is the Moon Agreement of 1979. However, the Moon has its limitations, which I will discuss further on as we proceed on this topic. So going further, we're going to be discussing 5 key elements as it relates to the issue of resource exploitation in international space law. Okay, so discussing further on the key point or elements as it relates to resource exploitation, as seen on the screen, we have the first, which is the responsibility of states, as provided under Article 6 of the Outer Space Treaty. Secondly, we'll be discussing the prevention of harmful activities, as recorded in Article 9 of the Outer Space Treaty of 1967. Third, we'll look at the Moon Agreement of 1979, which I talked about earlier on. Fourth, we'll be discussing emerging national laws and initiatives as it relates to the issue of resource exploitation. And then finally, we're going to look at the Artemis Accords, and we're going to know what it's all about. So moving further, we're going to be discussing the issue of responsibility of states. On the issue of responsibility of states, it is the duty of states to ensure that activities in space are deliberately and consciously supervised in order to avoid harmful activities being done on space, which will cause disastrous circumstances to other states. By virtue of Article 6 of the Outer Space Treaty, which records that state parties to the treaty shall bear international responsibilities for national activities in outer space, including the moon and other celestial bodies, whether such activities are carried on by governmental agencies or by non-governmental agencies, and for ensuring that national acts carried out in conditions set forth in the present treaty. Now, from the provisions of this article, we can see that state parties shall bear international responsibility for national activities that are carried out in outer space, whether it be the moon or celestial bodies, be carried out in such a way that it does not cause harm to other states, including the issue of resource exploitation. Now, it is no new news that we have some private entities like Planetary Resources in the United States who engage in the issue of going to space and getting out some materials, mining the asteroids, mining the moon, and bring them back to Earth to make some useful experiments and probably to sell off those materials. And so far, there have been no legal implications for the issue in the desire to carry out activities in outer space, including resource exploitation. States are under obligation to ensure that they do not cause harm to other states, as seen on the screen, that states are responsible for ensuring that both governmental and non-governmental entities comply with the Outer Space Treaty in their space activities, including resource exploitation. So moving further, we'll go to the second point, which is the issue of, we move on to the second point, which is the prevention of harmful activities. As seen on the screen, we see that a portion of Article 9 of the Outer Space Treaty clearly stipulates that state parties to the treaty shall pursue studies of outer space, including the moon and other celestial bodies, and conduct exploration of them so as to avoid their harmful contamination and also adverse changes in the environment of the Earth, resulting from the introduction of extraterrestrial matter and when necessary shall adopt appropriate measures for this purpose. Activities, including resource extraction, must avoid harmful contamination of celestial environment and must not interfere with the activities of other states as stipulated in Article 9 of the Outer Space Treaty. So we see clearly from this slide that states, in conducting their research and exploration and exploitation of space, they must ensure that in no way does harm come to any other country by reason of their activities. Now, as of yesterday, the 30th of January 2025, information reaching NASA is that an asteroid that is as large as the size of a football field is headed towards Earth. Now, whilst we have heard this kind of a thing over and again, as seen on the screen, while we have heard about stories like this over and again, we should not sleep on it, because there is a possibility that these predictions might one day come to pass. So states are advised that in the process of mining the asteroids or going into the moon or doing whatever they want to do in the moon, they should ensure that their activities do not cause harm to the environment. So a state or a state party can probably tamper with this asteroid in the process of doing space research, and then the asteroid hits the Earth. You know what that will cause to us as individuals. But then this all started because the state was careless in its actions in space. So it is proper that space activities should be properly, as earlier stated, the states should be responsible for whatever goes on in space. Failure to do this will attract sanctions from the state. Moving further, we'll go further to discuss on the third point, which is the Moon Agreement of 1979. As earlier stated, this agreement is one of the guiding principles, it's one of the guiding statutes that regulates space activities. The Outer Space Treaty is the main one. The Moon Agreement of 1979 is also another one. The problem with the Moon Agreement is that very few states have ratified to this agreement, and international law ratification is very important. Now, Section 12 sub 1 of the Nigerian Constitution clearly states that international laws are subject to our national laws, and any law that is to be accepted as international in Nigeria must first of all pass through the Senate and House of Representatives acceptance. So that goes to show that ratification is very important as it relates to the issues of space activities. Now, if Nigeria is not part of the Moon Agreement, then the concepts, the principle laid down in that agreement cannot be binding on us because we are not ratified to that agreement. The same goes to any other state around the world. So ratification is a very important thing and substance. Moving further, the Moon Agreement calls for the equitable sharing of benefits from space resources and establishes celestial bodies as a common heritage of mankind. However, as I said earlier, this treaty is ratified by very few countries and lacks universal acceptance. Now, one of the principles of international law is the principle of universality. Okay, so if this statute or this treaty were to be ratified by all the countries in the world, then there will be no need for it being voluntary. But as it is not ratified by most or all the countries in the world, then it's very shaky. So the current heritage of mankind here, as interpreted by some very notable scholars, is that whatever is done in space should be done for the benefit of mankind, for the benefit of mankind in general. And this is very, very vague and utopian, because obviously USA cannot carry out its activities for the benefit of all the countries in the world. Even if you were to do that, it can't possibly reach out to all the countries in the world by virtue of its activities on space. So this provision of the Moon Agreement is very generic. For the common heritage of mankind is very, very generic, and therefore needs proper interpretation. Going further, we'll look at emerging national laws and initiatives. And I stated, the Outer Space Treaty does not specifically say anything regarding the use of exploitation of resources as to whether or not it is right for countries to go into space and extract resources, and whether there are penalties for that. So in the absence of the Moon Agreement, the Outer Space Treaty saying anything on this regard, and in fact the Moon Agreement not saying anything as to the resource exploitation and limitations of resource exploitation, states and national entities have set up their own laws, as seen here on the screen. We see that some countries have enacted national laws permitting private entities to extract and use space resources. Obviously, United States of America, which is the foremost state that is interested in space activities, have a law, and that act is the Commercial Space Launch Competitive Act, which grants United States citizens and companies the right to own and sell resources extracted from celestial bodies. Now, as for Nigeria, I'm not aware of Nigeria having any act that regulates this. So it's left to our legislature to look into that and probably do something about it. Moving further, we see Luxembourg. Luxembourg also have a similar legislation that allows companies to exploit space resources under the country's jurisdiction. And then we have the United Arab Emirates and Japan. These are some of the countries that have been able to enact national laws as relates to the sale of resources that are exploited from space. So finally, moving further to discuss Artemis Accords. So as seen on the screen, it's a compilation of different states. But now, what is their goal? What is their aim as it relates to resource exploitation? Now, this slide goes further to show the principles, what it entails, what they are in for as a group of people. Now, it says here, principles for a safe, peaceful, and prosperous future in space. NASA, in coordination with the United States Department of State and 7 other initial signatory nations, established the Artemis Accords in 2020, with many countries and private companies conducting missions and operations around the moon. The Artemis Accords provide a common set of principles to enhance the governance of the civil exploration and use of outer space. The Artemis Accords reinforce commitment by signatory nations to the Outer Space Treaty, Registration Convention, the Rescue and Return Agreement, as well as best practices and norms of responsible behavior for civil space exploration and use. So, while the Outer Space Treaty is there, the Moon Agreement is there, Rescue and Return Agreement is there, all those agreements are laid down. The Artemis Accords is some form of watchdog, okay, over these nations, ensuring that there is compliance with the treaties that have been set up to guide the moon activities and space activities. So Artemis Accords is like a compilation of different countries saying, okay, we agree to the Outer Space Treaty, for example, and then we are intent on ensuring that the provisions of the Outer Space Treaty are protected.